The judgment which Mkhwebane is not happy with was delivered by Jafta in July last year.
The public protector was wrong to change the code. She could not have conceivably thought that willfully could mean inadvertently. These words are mutually exclusive. What she did went beyond the parameters of interpretation, but the finding itself is framed in terms that are concerning. The President could not inadvertently and deliberately mislead Parliament, because these two words cannot apply at the same time. It is either one or the other. Therefore, the public protector was wrong on the facts and on the law with regard to the issue whether the President had willfully misled Parliament, and the High Court was right to set aside her finding.
But Mkhwebane's attempts to have the Constitutional Court rescind the judgment failed earlier this year. Now she has turned to the Judicial Service Commission.
And the public protector is aggrieved because in writing that particular judgment, Justice Jafta does not make this acknowledgement that there are two versions out there and the public protector relied on the other, and that the Constitutional Court itself has previously relied on the same version that the public protector used. And so the public protector struggles to understand how this acknowledgement was not made when Justice Jafta had before him, as part of the record, an explanation about this very same issue, as well as a copy of the version of the Executive Code of Ethics that the public protector relied on.
Sekhalwe says Mkhwebane is not trying to appeal against the Apex Court's judgment.
This is not a backdoor appeal on the part of the public protector. She is alive to the reality that once the Constitutional Court has pronounced itself on a matter, that's pretty much the end of it. Her gripe is more on this allegation that she changed the wording of the Code of Ethics, because that couldn't be further from the truth.
The public protector says the judgment is posing serious implications for her legal career.
This is causing a lot of problems for the public protector, especially in relation to her career prospects, because already there are people who are gunning for her. They want her to be struck off the role of advocates purely on the basis of that decision. And it is for this reason that she has approached the JSC, which is a body empowered to hold judges to account where allegations of misconduct are made against them, or where it is alleged that they have misconducted themselves in breach of a code of ethics that is applicable to judicial officers. And so the public protector only asks for an apology, or at least an acknowledgement that she did not do what is suggested in the judgment in question.
But the judge's watchdog body believes there is no merit in Mkhwebane's complaint.
The problem with the public protector's complaint is that it relates to an order or judgment of the court. In terms of the law, there can be no investigation into the order or judgment of the court. The only options available is to take the judgment on appeal or review, or to get it rescinded. Public Protector Mkhwebane has already tried to get the judgment rescinded, but has failed to do so. And so she is now filing the complaint as a means of last resort for her. And so the Judicial Conduct Committee, which is responsible for holding judges to account for misconduct, will have to dismiss the complaint, as the complaint does not have merit.
Mkhwebane has launched a three-pronged approach in a bid to save her job and legal career. She has asked the Constitutional Court to reconsider its earlier decision on her impeachment by the National Assembly. She is also expected back in the High Court in Cape Town next week in an attempt to halt her removal from office and to prevent President Ramaphosa from suspending her pending the outcome of her rescission application in the ConCourt. Besent, SABC News.